This is TWiT.
Although nothing that happened in Charlottesville was a laughing matter whatsoever, there is some sort of sad irony, I guess, that one of the injured parties for everything that went down last weekend and in the aftermath were various tiki torch manufacturers who did not want in any way, shape, or form to be associated with what happened in Charlottesville. So this brings up the question for our trademark experts here. When your brand has been co-opted in a way like this, what can or should you do? Mike?
Yeah, so, the Tiki Torch people were in a very difficult situation here because their brand was being tarnished as a result of it being used by all of these white supremacists during the Charlottesville protests. So, our trademark laws really are calibrated towards unfair competition and infringement by another party, meaning that you're using somebody else's trademark or service mark in order to promote your goods or services in the context of a commercial transaction. So even though these folks were using the Tiki Torch, they weren't using it in the traditional trademark sense for purposes of triggering a claim for trademark infringement or unfair competition. So really, and I'd love to hear Professor McKenna's thoughts on this as well, but really what that leaves these brands with is kind of a PR campaign. You need to go out and make sure, as Tiki did immediately, said, look, we're not affiliated with this. We find it abhorrent. And, this kind of speech has no place for us and we don't support it as a company. I think that's exactly the right move. Engaging a PR campaign specialist or other folks is always a useful step. I think we see some very recent examples of this being successful. You may recall during Trump's campaign, there was Donald Trump Jr. tweeted a picture of Skittles and equated that to the Syrian refugee problem. And, Skittles, or Wrigley's rather, the owner of the Skittles brand, came out right away and said, look, we think that this is a completely improper, inappropriate analogy. Skittles are candy, refugees are people, and we don't think anything else needs to be said. So, I think the key is getting out in front of these issues quickly and taking decisive action to distance the brand from these particular comments. I think that's really the main thing that brands can do.
Right. Further to your Skittles or candy point there, even if the brand of the Tiki Torch manufacturer weren't being directly tarnished, did they have some sort of legal foot to stand on by saying, Tiki Torches aren't about this. They're about having a barbecue in your yard or on the beach. And this is, why we create these things. And this is the image that we have crafted our brand to convey. And I suppose they can't control if somebody decides to do otherwise with a product that is capable of it. But it echoes that Skittles type point, don't you think? Yeah,
it does. I mean, I'm very sympathetic as having represented a lot of brand owners over the years about these problems associated with a company's products or services. At the same time, though, you don't have all controlling power over how a trademark is going to be used. Right. Once you put it out into the marketplace, people are free to use it to an extent. And our trademark laws and other laws don't ultimately give you control over all manner of uses of a trademark. But, like I said, from my perspective, the most important thing is a really well-crafted, thought-out PR campaign that can be launched immediately is really the best antidote here.
Well, before we get Professor Mark McKenna's thoughts on all this, I want to welcome on to the show Matt Curtis, one of Professor Mark McKenna's students at Notre Dame and our co-host here at This Week in Law. Hi, Matt. Great to have you.
Hi, everybody. Sorry for being a little late, and I'm having a little technical difficulty, so we're just going to do audio today.
Great. Wonderful to have you in whatever shape or form, Matt. Glad you could jump on with us. We'll come to you in just a second, but right now, Mark, why don't you give us your take on the dilemma of the Tiki Torch companies?
Yeah, so I think I agree almost entirely. I mean, I think it's a good reminder that trademark law isn't built to deal with these kind of circumstances, and in general, I think it shouldn't be, because the same thing that's happening here in a more extreme way is when it happens when somebody wears Burberry clothing that the Burberry company doesn't want associated with them. And in general, trademark law is not oriented to prevent all uses that affect the meaning of a brand. I think it's actually a good reminder that of the limits of trademark law, that brands are largely creatures that live outside at least outside of the perfect control of the brand owners, because they require social meaning that's engaged in by and co-created by consumers and by the rest of society. And so that does leave the brand owners vulnerable to these sort of things. And in the main, that's a good thing, but it exposes them in the extreme to things like this. And so I think I agree that it's the best response to it is to speak. In brand owners, many brand owners, maybe not in this particular example because it's so extreme, but they're usually very reluctant to get involved in anything that looks at all political, because losing any block of your customers is a big problem. So I have a colleague who teaches at St. John's named Jeremy Sheff, who wrote a nice paper about this at one point. And one of the examples that people talk about regularly is Michael Jordan at one point reputed to have said in response to a question about why he isn't more socially active is that Republicans buy sneakers too, right? And so brand owners are really loath to get into these sort of situations where they have to police who's using or who's engaging with their brands until they get to a circumstance like this that's so extreme that they feel like they have to say something and or risk having their brand look like they're complicit in it. So it's a tricky situation. It's one that brand owners are pretty regularly having to confront, and most clients want to have more control over the brands, and the law actually affords them. I would say there's one example out there where maybe there actually is some legal action that can be taken, and I think it's not the Tiki Torch example, but it would be. You might have seen the stories about some of these folks down in Charlottesville using shields with what looked like homemade versions of the Detroit Red Wings logo placed on them, and what at least as I understand the facts right, which I might not, but what might differentiate that example is that those people were having those shields made with those logos, in which case it looks a little bit more like, not perfectly like, but a little bit more like a conventional trademark case where you're enforcing the rights in your mark against somebody else who's using it on and in connection with goods and services, as opposed to just buying your legitimate products, your Tiki Torches, and using them in ways you wish they wouldn't. And so that might be a circumstance where there's at least some conceivable legal response. But in the main, I think brand owners' recourse here is to speak.